Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk about not putting your property in other people's names. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, so this is something that I have been talking about more frequently, I guess, on TikTok and some of the shorter videos. But I wanted to have a moment to be able to go a little bit deeper and to talk about both sides of this coin, because I have talked about not transferring your property to your kids and the problems that can happen there. But I just recently had someone reach out to me literally yesterday with a situation where they had purchased a property in the name of their parent and some craziness that happened there. So I wanted to just take a minute to talk, sort of like I said, about both sides of those transactions, about why you might not want to do it, and just really encourage you not to do it, because it's ripe with problems, wrought with problems, okay? Whatever the right phrase is, there's a bunch of problems. So let's talk about it from the perspective of a parent giving their real estate to their child. Okay, let's talk about that first. And the problem that comes in this example is going to be the same problem that can come on the flip side as well, but it's just more likely to happen. So a lot of times parents will gift their real estate to their kids thinking that they're doing some good things for like Medicaid planning. Sometimes they just want to give them the house early. They don't realize that they're missing the step up in basis if they do that. So if you bought the house for $100K and it's now worth $1 million, if you would sell it, you would pay capital gains tax on that $900,000 of gain. Okay, don't worry about the exemptions and things like that. Don't worry about that. If you give it to someone, they take the property with your tax basis. So if you gave that same property to your child, if they sold it, they too would pay the tax on that $900,000 worth of gain. If, however, you give them the property after you die, they take the property with a tax basis of $1 million. No capital gains tax is paid on any of that growth. So that's one reason not to do it right there. But when you give up the property, when you give the property to your child or to your parent, you are giving up control over that property, period. You're not just giving up control as to whether or not people can live on the property or in the house, whether or not the property is sold or not. You're also giving up control over what happens to the property when someone dies. That's what happened in this example. So let's say you are a parent and you give the property to your child for Medicaid purposes or whatever. You're still living in the house. The deal was you're going to live there until you die, and then the child gets to do whatever they want with it. And the child unexpectedly dies, and the child has a will, and the will says that the house goes to their friend Susie. Okay, Susie comes in. She doesn't know about you. She doesn't care about you, and she sells the house, and you have to get out. So not only do you not get to live in the house, but you don't get to reap the reward of any of the proceeds, and neither does your family, because your child gave it away to somebody. Okay, your child could also get into a car accident and have a lawsuit filed against them and have a judgment against them and have that house taken because it's not their personal residence. Same thing could happen with a bankruptcy. Okay, same thing could happen, for any other various reasons that you don't want to have to deal with. In the example that I was told about yesterday, I got an email from someone who had purchased a property in their parents' name. I'm not sure what the exact reason was why they did that, but then the person that purchased the home, the actual purchaser, the child, paid the mortgage and did everything. The parent lived in the house, and the parent unexpectedly died. Okay. And the child continued to pay the mortgage, even though I don't think there's anybody living in the house or something. Something happened to the house. There was an incident. The house was damaged. Okay, so there was like an insurance claim that needed to be made against the house, but the insurance wouldn't take it. They wouldn't pay anyone. They wouldn't allow the claim because the owner of the property was dead. So they need to transfer the property from the parent to the child. There's a wrinkle though, because the child has a sibling, and because the parent died owning the house with no will, the house gets split amongst both of the children. Okay, 50-50. Now, normally that wouldn't be a problem. You think the other child, the sibling, would do the right thing and turn it over. The sibling was ready to do that, apparently, but the sibling's husband was not. So the husband refused to sign the paperwork, which for whatever reason they're supposed to sign wherever these people are. And now this sibling sees that she could be eligible to receive, several $100,000 because this is real estate. And she has kind of changed her mind about what she wants to do. And now this person who has paid the mortgage for all of these years is potentially out half of the value of the house because they made the decision to put the house in the name of the parent. So this is a word to the wise. You would think that these things don't happen all the time, but they happen all the time. That doesn't mean you shouldn't come up with a sort of a strategy to do this if you really want to. It is doable, but you need to make sure that you put protections in place. The way that you put those protections in place is to talk to someone like me. You're probably listening to this in some other state, so I can't even help you, but what I'm saying, call an expert and talk to them, learn about what the risks are, and do what you can to mitigate and minimize those risks, because they do exist and they can happen. And if they do, you want to have made sure that you protected against them. Okay? All right, that is it. Hopefully that made sense. If it did and you like this, hit the like button. If you have questions or comments, leave them. I will answer them. If you have questions specifically about other things related to estate planning or probate and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, that is it. As always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon.